So thank you very much for Anurag's introduction. Good afternoon, everyone. I'm very honored to be here to present my work. And we know that human rights have been introduced to address climate change for a long time because climate change is regarded as the common concern of humanity. However, for a long time, the utilization of human rights instruments is limited to the level of being rhetoric. Here I summarize 4 dilemmas for using the human rights instruments to deal with the global climate change problems. The first dilemma is that vertical duties and extraterritorial harm. Human rights law imposes vertical duties, which means duties owed by the state to those within its own jurisdiction. But climate change is the common concern that is expected to affect every country all over the world. The second dilemma is that the legal redress and political verdict, because human rights law is more of legalistic nature, but climate change is often seen as something for politics. So using human rights to address climate change may be viewed as an instrument to reinforce political pressure in the international arena, and the courts may be less willing to address climate change litigations. The third dilemma is the materialized violation with impending threat. The human rights law has the tendency to prosecution when injustice occurs, but climate change is only recognized as an inherently global threat to human rights, and climate change itself is not a human rights violation. Besides, not all infringements can amount to the breach of legal obligations. So the last dilemma is the individual nature and the collective action. Traditional emphasizes individual behavior and fails to consider the need for collective action, while states remain the principal and subject of international law. Emphasis on individual character beyond state borders to solve an environment of global nature is unrealistic. So in practice, solutions to international environmental issues like climate change require states' cooperation and collaboration. So the application of traditional human rights law to address climate change seems to face a lot of obstacles. Therefore, the utility of human rights instruments seems to be rhetorical rather than juridical. However, in today's presentation, I argue that there is the shift from rhetorical to juridical for climate change issues based on the development of environmental rights. So there are many developments in the field of environmental rights to justify this argument. Here I would like to identify 2 trends developed in regional environmental jurisprudence and the constitutional environmental regimes. Firstly, there is a role to play in the regional environmental jurisprudence. For instance, in the European Court of Human Rights, there are a lot of environmental caseloads. So by governing the living instrument of existing environmental law, the court has developed an elaborate and extensive body of case law, which all but in name provides for the right to the healthy environment on the basis of its creative interpretation of Article 2, right to life, and Article 8, right to respect for private and family life. So the court mainly specifies states' procedure obligations. And actually here, this is the same for the Uganda case, the most frequently mentioned climate change case, because the articles are applied directly with the rights to life and privacy in the European Convention on Human Rights as well. So here the Supreme Court of Netherlands upheld that Dutch government has an obligation under the convention to protect these rights from the real threat of climate change. Another example is the Inter-American Court of Human Rights advisory opinion on the environment and the human rights in 2018. So this advisory opinion is a response to Colombia's request regarding extraterritorial jurisdiction of state parties to the American Convention, in particular their obligations under the right to life and personal integrity arising from the operation of the large-scale transboundary projects in the Great Caribbean region. Although it does not expressively use the term of climate change, however, it can be relevant or applicable because climate change is also a kind of environmental harm and risks. So this is a landmark advisory opinion. on the environment and human rights, reaffirming that human rights depend on the existence of the healthy environment. The Inter-American Court of Human Rights ruled that states must take measures to prevent significant environmental harm to individuals inside and outside their territory. So in other words, if pollution can travel across the border, so can legal responsibility. Another role to play here is constitutional environmental regimes. The most important development is the constitutionalization of environmental rights. It provides a legitimization and a justificatory foundation for environmental care in a society and its law and governance system. So constitutional law fosters the comprehensive and holistic approach to the challenge of environmental protection because it facilitates a wide range of legal tools. Meanwhile, it provides grounds for climate change entering the legal and the constitutional domain, so the most fundamental legal area in the nation. And another relevant phenomenon is environmental constitutionalism. Actually, it means the entrenchment of the environment with constitutional importance. About 3/4 of states worldwide have enshrined some kind of environmental provisions in their national constitution. Environmental constitutionalism mainly works in the following two ways. Firstly, constitutionalism is closely tied with basic principles of the society and the legitimacy of the sovereign in decision making, so it can spur stronger or more comprehensive domestic environmental climate legislation. Secondly, constitutional environmental provisions can inspire litigation for environmental protection and climate change because courts have the duty to refer to or to interpret constitutional provisions. Another phenomenon that may be relevant, but we need to argue for, is global environmental constitutionalism. It's mainly related to the normative principles and institutional arrangements, such as the human rights, state responsibilities, and the peremptory norms like jus cogens, erga omnes, etc. So, although we still need to argue for this, but nevertheless, it's our ideal or our objective to expect a solidly integrated, participatory, accountable, and democratic global environmental legal order. So to summarize, there are generally two trends in current development of environmental rights: greening existing human rights law and recognizing an explicit right to the environment. Actually, the latter one is not only happened in a lot of national constitutions, in many regional treaties, such like the African Charter of Human Rights, of Human and Peoples' Rights, Arab Charter on Human Rights, ASEAN Human Rights Declaration as well. At the international level, there are also many declarations and resolutions regarding to the recognition of the fundamental right to the healthy environment, from the Stockholm Declaration, Rio Declaration, to the more recently the draft International Covenant on the Human Rights to the Environment, draft Global Pact for the Environment, and the Framework Principles on Human Rights and the Environment, etc. So to some extent, it can be argued that there is even enough state practice and opinion juris for environmental rights to be regarded as the customary international law. Although the conclusion for environmental rights as an emerging international custom may be debatable, but nevertheless, the development of environmental rights does map the trend for shifting climate change problems to a juridical ground from the following perspectives. Here I summarized here. The first is it identifies the duty to prevent transboundary environmental harm as the matter of human rights law. This can be based from the Inter-American Court of Human Rights advisory opinion. The second is it raises climate change beyond the level of global politics because of climate change has become, we can argue that climate change has become of constitutional importance as kind of environment protection. And then it facilitates domestic climate performance in terms of legislation and litigation because the role that constitution, environmental provisions, and also the role of constitution plays in the nation. Lastly, it can increase participation democracy and accountability globally, if ideally under the development of global environmental constitutionalism. So, in a word, we should not only focus on the human face of climate change, but also need to look at its environmental fault, and this is where climate change is rooted in. So that's all for my presentation. Thank you very much for your attention and patience.
Thank you very much, Lee. A fascinating presentation. I noted many points down, so I'm looking forward to the questions on this one. Now, if we could move on to our second speaker this afternoon, Poonam.
Hi, can you hear me?
Yes.
Yeah. So,
hi, there you are.
Yeah, so I'll just try to share my presentation now. The shared tray is not showing anything. Just give me one moment. Yeah, on my share tray, I cannot share. Can you give me some guidance?
Okay.
Hi there, Poonam, it's Gillian. I wonder if you want to quickly email your slides to the SRN email address. We can put it up and then you could request control. It might be easier.
All right. Yeah, just one moment. I'll just send it. So I can send it to the law SRN at the QUB.ac.uk.
Yes.
Yeah. So if you send it to us, we can then.
Okay.
Yeah.
Yeah. Sorry.
No, you're grand. Don't worry.
Yeah. Yeah, sent.
Okay. Okay, I can share my screen, and if you'd like, you can request control.
I think it's already coming up just now.
Oh, okay.
If you just request control, then Poonam.
All right.
Great. Gillian saves the day. Thank you, Gillian.
Okay. So where do I request the control from?
At the top, it should say take control.
Oh, yeah. Got it. All right then. So hi everyone. I'm a PhD candidate at University of Lapland, and my name is Poonam. And I have been doing this research for the last couple of years. It's on Arctic Indigenous peoples and basically like how they influence the international climate law framework. So my PhD is a combination of 4 articles where I deal with 2 main research questions around these areas. So what is the role of Arctic Indigenous peoples' traditional knowledge in influencing international climate change law? And how the recognition of Arctic Indigenous knowledge in international climate law making contributes to promoting the Arctic indigenous peoples' resilience at regional level. So like this is one of the articles and it is in a draft condition. So I'm hoping to get a lot of comments from you guys. So the Arctic is susceptible to the risks posed by climate change, and the Arctic Climate Impact Assessment from 2004 has already set out the scene about how climate change in the Arctic was already happening at a faster rate than other places across the world. And recent studies show that it's so fast that there is no predictive, there is no way to predict how the Arctic is going to change in the coming years. And this has had significant implications for the whole world, as Arctic is said to be the refrigerator for the whole world. And climate change in the Arctic has also massive economic and cultural impacts on Arctic indigenous peoples' lives. Sorry. Yeah. So the relationship of Arctic indigenous peoples with climate change is very very integrate and very intertwined. And indigenous peoples generally amounts to a 5% population of the world, but in the Arctic the proportion of indigenous peoples is approximately thought to be 10% of the total Arctic population. And climate change is, although we know that climate change is more of a global phenomenon, having its impacts across the whole world, and all the population, not only indigenous population, but the experience of indigenous communities as to climate change differ depending upon the region they reside in. And also they have a propensity to be located in the most vulnerable locations in the world, and in the Arctic it is more so. So in the Arctic, the climate change is causing indigenous communities to lose land and natural resources, which is very essential for their survival and their unique lifestyle, and what is called to be the traditional livelihood aspects, which is very, very heavily impacted upon because of climate change. And climate change is also causing indigenous communities residing in the Arctic like Sami, Inuit, and Chukchi to experience severe impacts locally to their everyday life, like whaling, sealing, fishing, and reindeer herding. There has been several reports in Lapland, where I live here right now, that herders have complained that reindeer population is declining massively, mainly because they fall through the melting ice, because now there is no prediction about how the ice is going to be. And also the reindeers sorry, excuse me. Also the reindeers are habituated to a general routine of having more ice. When the snow becomes hard, it's easier for them to walk around on the on the sea. So because of not being able to predict, and also the herders are not also aware of when the climate is going to shift. So reindeers fall through the melting ice, and also there has been occasions that they could not dig up the food from underneath the snow because it was so hard. And also indigenous communities across the globe has different cultures and are different in many ways, but realities of climate change is very similar. And it is said that there is some sort of commonality among unique indigenous communities. And also, previously, Arctic indigenous peoples have had a role in advancing climate litigation. So, the consequences of climate change faced by indigenous population was confirmed first through the Inuit petition in 2005, and it was brought about by the Inuits residing in America and Canada, I think mostly. So the petition essentially focused on the United States of America, as it is the largest emitter of greenhouse gases, and it has refused to come in line with international efforts made to reduce emissions. The petition particularly asked the Commission to affirm that the United States of America was in violation of rights guaranteed under the American Declaration and Duties of Man of 1948, and other international law instruments. It was urged in the petition that the Commission recommends that US takes measures to limit its emissions of greenhouse gases and collaborate with the community of nations to restrict dangerous anthropogenic interference with the climate, which is the objective of the UN Framework on Convention on Climate Change. And in this petition, it was also asked that the Commission affirms that the USA has a duty to work along with the Inuit to establish a plan to assist Inuit, adapt to inevitable climate change impacts, and also to consider that the impact of US's emissions on Arctic and the Inuit prior to giving approval to any major actions of the government which would have an impact on the climate in the Arctic. And the petition was rejected, and the petitioners were informed that, you know, like, the petition was not taken into account because the information it contained did not satisfy the requirements set forth in the rules of the IACHR. And the Commission also stated that the information provided was not enough for them to determine whether the alleged facts would tend to characterize a violation of rights protected by the American Declaration. Although this was the situation, but, you know, like, this actually gave other indigenous peoples across the world some sort of like standing to bring forward their petitions to different human rights councils and commissions. So there was another of similar kind of petition brought about by the Arctic Athabaskan Council against Canada, and also, like, you know, it was rejected. But I think this brought like limelight to the issue of how Arctic indigenous peoples were very badly impacted upon because of climate change. And also, like, I think it brought some sort of conversation regarding climate change and human rights. I think that was the beginning of something in that line of arguments. And also, like, you know, I wanted to talk about like Arctic indigenous peoples' engagement in climate politics, because I basically talk about their involvement and inclusion in UNFCCC proceedings. So the Arctic indigenous peoples and the organizations associated with them have been at the front line of political activism in national and international platforms previously. And the IPCC's fourth assessment report only made reference to Arctic indigenous communities in their summary, their geographical location being one of the factors for which they were highlighted in such documents. But now, you know, like, there are more and more situations where Arctic indigenous peoples are also, like, you know, taken as like, you know, action, like person who takes people who take action against climate change. And also, like, you know, since the Arctic Council came into form, Arctic indigenous peoples have very, like, you know, very actively been involved in Arctic Council's decision-making process about climate change. And the Arctic Climate Impact Assessment also considered the environmental and social impacts of climate change on peoples residing in the Arctic. According to the report, Arctic indigenous groups has been recognized as holders of special knowledge by global change, science and policy forums, and this knowledge has been deemed to be significant for tracing and comprehending local indicators for environmental change and the interactions between nature and society. And within the assessment, like, you know, Arctic indigenous people were like brought forward as harbingers of what climate change has in stock for the whole world. And Arctic indigenous peoples have been speaking on behalf of at-risk cultures and livelihoods. As such, they have become relevant spokespersons. And, like, you know, I will just briefly talk about how Arctic indigenous peoples' involvement at the UN generally has brought forward like indigenous peoples' rights issues in the world, and how they have also advocated for other indigenous peoples' rights, and how they, like, you know, brought they brought unity amongst the indigenous peoples around the world to come forward in the UN platform to talk about their own rights. So, you know, like taking their own rights in their own hands and talking about it, participating actively. So that's why I think it is very important important to talk about Arctic Indigenous peoples' role, although, like, you know, I think all Indigenous peoples have some sort of role in this climate politics scene today, but it is also true that, you know, like Arctic Indigenous peoples' engagement in climate politics has also helped Indigenous peoples as a whole to get their rights in international forums such as UN and also the UNFCCC. So when the Arctic Climate Impact Assessment was published in 2004, Inuit representatives led the first initiative at the UNFCCC for the recognition of the human rights impacts of climate change. And since then, they were participating in the UN process, actively, UNFCCC process actively all throughout. And as a result of that, the Paris Agreement came into form, and Article 7.5 talks about the importance of, participation of Indigenous peoples in all these climate-related conversations. And, you know, like as an effective effort to enhance the Indigenous peoples' participation at the UNFCCC following the Paris Agreement, a permanent platform for local and Indigenous peoples has been created in 2019, which was like after 2 decades of strategic Indigenous involvement in the UNFCCC process. And like still now there are inequalities of power and resources which exist, and also like, you know, the matter about how reachable UNFCCC process is for most Indigenous groups. But, you know, like it seems like it's a good way forward. And in concluding, I would say that Arctic Indigenous peoples' inherent and recognized relationship with the nature they reside in makes them care, observe, and accumulate special knowledge about the environmental changes and climatic shifts. There are thus important political voices which should be heard at the international level when the political negotiation is regarding climate change specifically, and of course about other issues, but with climate change they hold like special. And since Arctic is considered to be drastically facing climate change at an unprecedented rate, the Indigenous peoples living in the region are being threatened too, as to their economic sustenance, food systems, other livelihood activities. So I think it is very, yeah, sorry.
Sorry, Poonam, you're just at the end of your time there.
Yeah. So, you know, like I believe that, you know, I would argue for their participation in the international platform. So that's it. Thank you.
Thank you very much, Poonam. Another fascinating presentation. Just so that we can keep to times, if I could please invite Orla to make her presentation.
Can you guys see my slides?
Yep.
Okay, great. So hi everybody, my name is Orla Gallagher and I'm going to be talking today about whether a state's individual contributions to climate change can be accommodated within traditional legal doctrines like causation and what I call systemic rights-based climate litigation. So I essentially argue in this paper that accepting a material contribution to risk of climate harm as sufficient causation can help overcome many of the difficulties this doctrine presents in climate litigation. And I would argue that this aligns quite closely with Henry Hsu's theory of climate justice because it forces governments to at least at a minimum take responsibility for their own contribution to the problem of climate change. And I would also argue that it prevents governments from trying to extricate themselves from responsibility by, for example, pointing to their relatively small emissions on the global scale, or by pointing to other countries who are maybe not doing their part to tackle climate change either. So just trying to move forward my slides. So as a concept, very briefly, climate justice is a concept that focuses on sharing the burdens of climate change fairly. So philosophers have referred to 3 different kind of principles for allocating responsibility for climate change on a moral basis. So contributor, polluter pays, ability to pay, and beneficiary pays. And Henry Hsu's very useful contribution to that is that these principles tend in principle to converge upon the same states, namely wealthy developed countries, at least initially, bearing the lion's share of responsibility for tackling climate change. And I don't think it's particularly controversial to try place Ireland and the Netherlands in that category. So that normative principle or theory of climate justice is broadly reflected in the expectations and general principles and objectives of international climate law in terms of what's expected of developed countries. So concepts like common but differentiated responsibilities, equity, and developed country leadership. So I'm now going to try superimpose or to try apply some of this theory of climate justice to two judgments. So the Urgenda judgment, which was referred to briefly in Lee's presentation, and also the recent judgment in Climate Case Ireland, or Friends of the Irish Environment versus the Government of Ireland. So in terms of the Urgenda judgment, so for those who maybe are not aware of it, in 2013, Urgenda, a NGO in the Netherlands, initiated a class action against the Dutch government, alleging that the Dutch government emissions levels were unlawful. So they sought a mandatory order to reduce emissions by 40% by 2020 compared with 1990 levels, or at a very minimum a 25% reduction. And those figures came from AR4, which was the IPCC's advice, and that had been repeatedly endorsed through the UNFCCC and Kyoto Protocol conferences of the parties. And so that advice had been repeatedly accepted by the Netherlands and by the EU as the parties had signed off on that. And so Urgenda essentially claimed that the Dutch government's climate or carbon emissions were unlawful under Dutch tort law, but also that they violated Article 2 and 8 of the Convention. So in 2015 then, the Dutch District Court accepted Urgenda's arguments and ordered at least a 25% reduction by 2020, but it based its judgment on Dutch tort law. On appeal to the Court of Appeal, that was upheld, but on the basis of ECHR law. So for time constraints, I'm just going to focus on a few elements from the Supreme Court's judgment, which was handed down about this time last year. So the Supreme Court again upheld that judgment of the lower courts, again on human rights grounds. The Supreme Court stressed that states that the Dutch state had a positive obligation under Article 2 and 8 of the ECHR to take preventative measures to mitigate a danger, so in this case climate harm, where there's a real known risk of real and immediate risk to people's lives and welfare. So that was so even if the danger was in some way uncertain, even if that risk of environmental harm would impact a huge cohort of people, and even if that harm might not materialise for in the short term. So essentially what the Supreme Court said was that partial fault justifies partial responsibility. The Supreme Court said the fact that other countries were maybe failing to do their part, or that Dutch emissions were relatively small on the global scale, wasn't really an excuse for the Netherlands to fail to perform its own individual obligations, as otherwise every state would be able to extricate itself from responsibility. And there wouldn't be effective remedies for climate litigants. So the Supreme Court also found that the government hadn't really explained why it should be entitled to an emissions reduction target less than that which had been widely agreed via the COP decisions, and placed particular emphasis on the Netherlands' very high per capita emissions. So I would argue that this approach aligns very closely with that concept of climate justice I spoke about earlier. The Supreme Court in particular emphasised the Netherlands' special position as a wealthy country that had accrued much wealth from fossil fuel exploitation, and I would argue that that aligns quite closely with this concept of climate justice. So the second case I want to talk about then is the Friends of the Irish Environment case. So in that case, FIE, which is an environmental NGO, was challenging by way of a judicial review the government's approval of the National Mitigation Plan, which was the Irish government's for climate change, and was challenging on the basis of being ultra vires, and that also breached Article 2 and 8 of the Convention and constitutional rights. So FIE placed particular reliance on the fact that emissions were actually going to rise over the lifetime of the plan, but and again relied on that same scientific evidence as their agenda about the Irish government, like the Dutch government, having repeatedly endorsed that AR4 advice. But the High Court found that the government enjoyed a lot of discretion in the area of climate under the Act, and that as a result, the court really wasn't in a position to be second guessing the government. So the High Court found, without really much elaboration, that the approval of a national mitigation plan didn't actually breach constitutional rights or put them at risk. In other words, the High Court said there was no real causal link between the Irish government's approval of this plan and a breach of rights. And I would argue that the problem with that line of analysis is that it fails to elaborate on how NMP that was allowing emissions to rise could be considered, whether that essentially in allowing it to allow emissions to rise, that it created a risk of adverse climate impacts, and whether that could be tantamount to constitutional rights breach. So on the alleged ECH4 rights breach, the High Court refused to attach any weight to the agenda judgment on the basis that the Strasbourg Court hadn't yet ruled on the matter of the application of the Convention to climate harm. And in doing so, I would argue the High Court closed itself off from a very pertinent line of analysis in our agenda that had extrapolated principles from the Strasbourg Court on Articles 2 and 8 and environmental harm, and essentially had concluded that contributing to a real and immediate risk of harm, that was in itself amounted to a violation of rights. So I would argue that the High Court's analysis of that rights dimension of the case is particularly difficult to reconcile with the concept of climate justice. The judgment essentially allowed a developed country that should have been taking mitigation, leading the way on mitigation measures, to evade responsibility for actually growing its emissions based on the wide discretion of the executive, but also on an unwillingness to actually look behind the climate plan itself and scrutinise how it might impact on rights. On appeal to the Supreme Court did in fact quash the National Mitigation Plan, but did it on very narrow grounds, on statutory grounds. So the Supreme Court based its judgment on the statutory obligation under the 2015 Act to specify how the government was planning to achieve its 2050 target. So the Supreme Court dismissed the constitutional and human rights aspects of the case on procedural grounds. So basically, Friends of the Irish Environment as an NGO didn't have standing to litigate personal individual rights. So in conclusion, I would argue that, I suppose, whether the Irish courts would be willing in future to accept this idea of a material contribution to risk of harm as being enough to ground an alleged rights violation in future climate cases, it remains quite uncertain in the wake of the recent climate case judgment. Even though the Supreme Court, skirted around these questions, it did kind of maybe suggest that it might be open in future to more environmental constitutional arguments. And I would argue that there's reasons at least to believe that the Irish courts would be willing to entertain this line of argument that material contribution to risk should be enough. So I think there's maybe two reasons for that. The first is that there are currently two climate cases that have been filed with the European Court of Human Rights in Strasbourg. I would argue that if these are accepted and if they're successful, the Irish courts will no longer be able to argue that it can't rule on this matter because the Strasbourg courts haven't yet decided if the convention can be applied to climate change. And the second, I would argue, is that if the superior courts are in future willing to engage with constitutional and human rights arguments in the future in climate cases, the Supreme Court could draw on its existing jurisprudence in the area of causation in toxic tort cases. So, for example, it has been accepted on public policy grounds in common law jurisdictions that a material contribution to risk as a test could satisfy a causation requirement for liability in toxic torts where you have an indivisible injury, for example, in mesothelioma cases. And I would argue that there is certainly strong policy grounds here in the context of climate change, stemming from both the urgency of the crisis, but also the complexity of the causes. And
sorry, Orla, you're just coming on time there.
Oh yeah, no problem.
Apologies.
One last sentence to wrap up, but I would say if that were the case, that kind of approach would align a lot more closely with the concept of climate justice. So that's it for me. Thanks very much for listening.
Thank you very much, Orla. Fascinating presentation on two highly important, highly topical cases currently going through the courts. Moving swiftly on, I'm going to invite our discussant, Dr. Amanda Slevin from Queen's University and from the Centre for Sustainability, Equality and Climate Action. Amanda is a great colleague of mine in the SECA. We've worked on numerous projects together. So if I could invite Amanda to take the floor, please.
Thanks, Anurag. Well done, everybody. Really, really interesting papers. And I think each of you have really articulated the entwined climate and ecological crises as the greatest challenges our world has ever faced. You know, each of your papers has drawn attention to the intersections of socioeconomic, legal, political, ecological and ideological domains and how these are manifested within climate legislation, but also their practice and consequences. You know, you've drawn real strong attention to the science basis for climate legislation and the real life impacts that we're seeing across the world, as Poonam has really pointed out, the consequences for Arctic Indigenous peoples. And we know that there are major socio-ecological, economic and political risks inherent to climate breakdown. You know, the questions of rights, risks and responsibilities that you've all really well articulated are mirrored in important research, such as the IPCC report from 2018, which highlights how poverty and disadvantages are expected to increase in some populations as global warming increases. And that we know that limiting global warming to 1.5 degrees centigrade compared with 2 degrees could reduce the number of people exposed to climate-related risks and susceptible to poverty by up to several hundred million by 2050. They highlight how climate-related risks to health, livelihoods, food security, water supply, human security and economic growth are projected to increase with global warming of 1.5 degrees and increase further with 2 degrees. I think what's really interesting from each of your papers is the articulation of the inherent socioeconomic inequalities associated with climate breakdown. As Orla, I think, showed in one of your slides about the injustices about who emits most emissions. Reports by the UN highlighted how about the top 10 emitting countries emit about 45% of global emissions, yet the bottom 50% of countries emit only 13%. So we see that so-called developed countries in the global north, particularly the US and Europe, have produced the most cumulative greenhouse gas emissions since 1850, around the time of the advent of the Industrial Revolution. But poorer countries which bear least responsibility for emissions experience the worst consequences, as we've seen really clearly through Poonam's presentation. And we know that even in wealthier countries such as in Ireland and the UK, that climate change will have disproportionate impacts on poorer groups as well. So this is a matter of global injustice, global inequality, but also within our own states as well. What I find really interesting about the three papers was how you brought together a multi-level analysis and paid attention to the actions at different levels and scales that are necessary to tackle the climate and ecological the climate and ecological crises. And we can see through the three papers how the macro level of international and national climate regimes has been illuminated in relation to risks, rights and responsibilities. We can see attention to the meso level of communities and organisations demonstrated through, on one hand, articulation of the necessity of involving Indigenous peoples and minority groups in decision making, but on the other hand, how social movements will hold states to account when they fail to take responsibility for their contributions to the climate crisis. And inherent to each paper is the micro level of individual agency and the activities people undertake to advance climate action, as demonstrated really clearly, I think, through the last two papers. Now, I should confess I'm an environmental sociologist, if it isn't clear already through what I've already said. So if we take and view law as a social construct, we can see within each paper implicit questioning of how societies function generally, and specifically how they respond to climate breakdown via legislation. Within modern capitalism, the value of nature is often equated with monetary value in terms of how natural resources such as fossil fuel resources are regarded as commodities for profit making. The greenhouse gases associated with production and consumption of these resources are often seen as an unpleasant externality, the costs of which are borne by societies, environment and minority groups. Thankfully we see dominant thinking to be changing, but we're quite a while to go to see alternative forms of society-environment interactions in which the intrinsic rights of nature and human nature interdependencies are valued. I think Lee and Orla's paper illustrate conflicts within states regarding continuation of established patterns of political economy and associated legislation designed to protect the status quo, and reveal clashes related to the embedding of environmental human rights as key strands of climate justice. Their papers illuminate broader tensions between business as usual approaches and inherent to how states function, how states' political economy, and also how states mitigate and adapt to the consequences of climate breakdown, in turn raising very important questions of rights, responsibilities and justice. We see in Poonam's paper and also in Orla's how the dominant state of affairs does not have widespread support, particularly among Arctic Indigenous peoples. And Orla's paper also reveals broader discontent and how critical social analysis and action is vital in the establishment of climate legislation that forces governments to take responsibility. Lee's paper serves as an important reminder that the situation of climate change consequences as human rights infringements has to move beyond rhetoric to practice, calling attention to the obligations of states to regulate environmental climate risks, enforce climate laws, and also disclose environmental climate information. In turn, stressing legislation which embeds both environmental and human rights is necessary to contribute to the legal redress of climate challenges. And I think each of your papers has really emphasised the variety of research that we need to understand the scale of the challenges ahead, but also to understand the pathways that we can take to respond to these massive issues that we're facing. So I'm going to refrain from going into the details of the legality of some of the presentations because that's outside my comfort zone slightly. And I'm sure there's other people in this seminar who will focus on the minutiae of the climate legislation that our esteemed panel have drawn attention to. So I'm just going to go to each of the three participants with some observations and questions. Lee, I have to say I'm sorry that I missed the first few minutes of your presentation. I had problems logging in to the session, but what I did here was very interesting, so thank you. I missed the opening part of your session, so I'm not sure if you talked about the methodology underpinning your research. So I'm interested in understanding what states are you focusing on? Have you done comparative case studies? So generally, a bit of insight into your methodology and approaches you're taking in your research. I think it was interesting to hear about your focus on environment and climate and environmental human rights legislation for climate action, and I suppose in tandem with more critical analysis of states, how states function and the relationship between politics and economy, and also how climate legislation can conflict, and it should conflict, with taken for granted processes such as oil and gas extraction. So I'm wondering, have you thought about broader political economy within states and how that shapes their responses and treatment of natural resources generally, but also the challenges that then in turn presents for climate legislation and action? And I suppose this will overlap a little bit with some of the questions that I'll put to Orla in a few minutes. But I'm interested in states, for example, that are dependent on revenues from hydrocarbon extraction. What are the particular challenges in those states when we have deeply embedded attachment and dependency on fossil fuel extraction? How does that impact on the evolution of environmental and human rights legislation? What about the conflicts and challenges that are manifested in those particular states? Because not every state is different. Every state has different socioeconomic and political and ideological forces shaping how it evolves. So I'm interested in those particular states which are dependent on fossil fuel extraction. How do you reconcile those political economic demands with what is needed to move towards stronger environmental human rights legislation? And I don't know if you've given thought to this, but what are the particular barriers to the implementation of environmental and human rights legislation in countries such as UK, Norway and others which are dependent on fossil fuel extraction? And what differences might we see due to the specific composition of states and different forms of political economy? And so this is quite political economy. I'm a sociologist, so I apologise. But I think these things affect how legislation is formed, and we see particular conflicts within states. So have you given attention to that within your research? But really, really interesting paper. Fantastic to hear your research and how you're focusing on the participation of really important groups in decision making. I think you've given a really well articulated overview of how climate change impacts upon Arctic Indigenous peoples, and focused on how they are leaders for other Indigenous groups more broadly in holding states to account and driving national and international climate frameworks. I'm interested in how you are assessing the participation of Arctic Indigenous people in the negotiation processes. So are you trying to quantify their participation? What measures are you looking to assess and evaluate participation? I'm really interested in how you've referred to different forms of knowledge and their treatment within climate negotiations. So are you looking at a specific conceptual framework which interrogates different forms of knowledge in society and how different types of knowledge are valued and others are not? In that vein, have you looked at Ulrich Beck, his work on risk society, and his divisions between expert and lay knowledge? So his work focuses on how socio-ecological risks like climate breakdown give rise to the evolution of lay expertise, in which non-traditional experts, so those outside traditionally the university sector, develop expert knowledge. And we can see that really clearly in the case you've given of Arctic Indigenous peoples. And their knowledge and their different ways of understanding and relating to the natural world. How does that challenge traditional expert knowledge that might be manifest normally in international climate regime? So interested in hearing a bit more about your framing of knowledge clashes within this process. Okay, so I think that's hopefully clear enough what I've asked there, but just a bit more articulation on your framing of knowledge and clashes of knowledge and understandings and ways of being, and what conceptual framework you're using to examine that within your research. Orla, really, really exciting paper. Fantastic to hear about the role of climate litigation and forcing governments to take responsibility for their contribution to climate breakdown. I'm particularly interested in your two case studies, as my own PhD focused on hydrocarbon extraction in Ireland, and I examined some of the conflicts around the state's desire to ramp up oil and gas extraction using excuses like economic benefits and security of supply. I undertook a part of research in states like Norway, unfortunately not the Netherlands, but you did talk about fossil fuels and the role of gas extraction in the Netherlands as well. So I'm interested in just hearing a bit about more, I suppose it relates to sort of the broad questions that I put to Lee about the intersections of climate policy and energy policy, and how do we reconcile those competing demands and conflicts when we're looking at climate legislation and the two cases that you've talked about. I'm also interested in, I suppose, a bit of a divergence away from the analysis that you've given, but also the power of social movements in litigation. And I understand that may be something you're not comfortable talking about, but just hearing your thoughts on that would be really interesting. And yeah, how do we progress forward when we have, we're states such as Ireland and the Netherlands, which have a drive towards continued extraction. Now, Ireland has put a moratorium on new licenses for oil and gas extraction, but the state, if you look at the state's political economy, it's very much based on natural resources as being there to be exploited for human profit making. How do we reconcile those issues when we look at climate legislation and climate action? So I think that was very brief and probably a bit too rushed overview of some of my thoughts and observations on three really exciting papers. So thank you very much, everybody. And if you want me to clarify anything that I said there, please let me know.
Thanks very much, Amanda. In the interest of time, I'm afraid I'm going to have to limit the answers to, I think, 5 minutes each. So in the order that Amanda asked the questions, Lee, would you like to go first, please?
Yes. Thank you very much for Dr. Slevin's insightful comments and very interesting questions. Yes, so firstly, I would like to address the methodology issue, because for me, this is a paper based on the doctrinal methodology, because the materials that I need can be found from the journal articles of a lot of writers, but actually there some quantitative studies have been done by some scholars. For example, the quantitative study is about how many countries in the world have already adopted kind of environmental rights in their own constitutions. And according to their result, it says about over 3/4 of countries in the world have adopted some kind of environmental provisions in their constitution, and explicitly the right language. With the right language, they are about more than 100. So we can see that this is a large proportion of states in the world. So this is about kind of rights related to the environment. And also, for the case studies here, I mainly introduced 2 case studies. They mainly from the first is about the regional environmental jurisprudence. It's from the European Court of Human Rights and also the Inter-American Court of Human Rights advisory opinion. So we can say that both of these courts, they have, although especially for the European Court of Human Rights, because under the European Convention on Human Rights, there is not an explicit right to environment provision, but the court is really creative in this aspect. It interprets the Article 2 and Article 8 about right to life and right to privacy to grant the kind of environmental protection to those relevant victims. And also in the Uganda case, actually, the Dutch Supreme Court has kind of borrowed this creative interpretation and enforced the decision. So, and another case study is about the Inter-American Court of Human Rights advisory opinion. So although it is not expressively addressed on the issue of climate change, but actually it addressed the really very relevant issue is about the extraterritorial environmental harm, because the court said that they have the responsibility to ensure that it's any of its activities that can cause harm to the other countries extraterritorially, they should have the kind of responsibilities. So it means, for example, especially for climate change, it's kind of the global nature environmental problem. So here, maybe we can borrow some lessons from this jurisdiction. And also, as for your second question, is about the political and economic demands. Here, I need to stress that the recognition of the right to the environment is not very easy. So far, internationally, there is not an explicit recognition of this right. So from this, we can sense that how fierce the opinions, how contentious it is, because of a lot of political and economic issues relevant here. Because there are some scholars advocate that there are about 3 kinds of generation of rights. The first right is about first generation is the right to civil political rights, and then the second is economic, social, and cultural rights, and the third generation should be environmental rights. However, not all countries in the world have acknowledged such rights, especially some developed countries like the USA. Yeah, so we can say, and also it's relevant with the capitalism thing, because in the because under international law, the state's interest is really important, and climate change, the results can also be contributed to some large. So why my title is said that from rhetorical to juridical, because rhetorical previously it was said that climate change, the human rights to climate change is mainly kind of political rhetoric, because we may just use the human rights as a language to, especially from those developing countries.
Sorry, I'm just gonna have to be a little bit firm with the time. If you want to, you have like about 30 seconds anyway. So if you want to wrap up your answer.
Yeah, okay, so my general answer is that actually there do exist a lot of issues here about the debates whether the right to environment has been recognized because of the hidden political and economic considerations. And it's not easy, but as environmental law scholar, I think we can argue, yeah, at least we can do some contributions to push the climate change litigation or legislation forward, yeah. Thank you.
Thanks very much, Lee. Poonam, would you like to go next, please?
Yeah, so thank you so much, Amanda, for your comments. And, you know, like for the assessment of the participation, I'm actually looking through the COP negotiations and like the documents that has been submitted from the Indigenous peoples at large. But for my, like, you know, understanding, I'm going to do some interviews next year, hopefully. So I have been emailing the Indigenous Peoples Secretariat, which is in Copenhagen, who participates in the Arctic Council meetings, and it is the Arctic Indigenous Peoples Secretariat. So I'm hoping that they will be able to help with like what kind of contributions they have made. So like, you know, I will have like proper data to support my arguments, because I have already found a lot of articles talking about different kind of participation issues from the Indigenous peoples at large. But, you know, like with Arctic Indigenous peoples, they have been at the lead of advocating for Indigenous peoples' rights at the UN and UNFCCC. But, you know, like the exact evidence about like how much participation has been made is not there. So I think through the interviews, I can collect that kind of data. So as I said, it's a draft. So it has like a lot of content right now, like the substantial content is already there, but it's not like there yet. So I need to do the interviews next year to get through to that. And with the knowledge clashes, I have already written one of my articles and it has been published. So with that, like, you know, I talked about how ecological restoration can be helped through different kind of knowledge systems and how it is a recognized process in adaptation matters regarding adaptation. So like, you know, how traditional knowledges and scientific knowledges can be combined to get actual results, which is important for climate change, because scientific knowledge at large is failing right now to, like, you know, adapt to the climate change issues, because, you know, like it's not predictable. And also suppose for in my example, I have talked about ecological restoration. So to restore a locality, you need to know about the previous condition of a locality. So for that, you need to get in hands like local knowledges and also indigenous knowledges. So like whilst local knowledges are also important, but, you know, like indigenous peoples observes the land and the earth system and other like water system and all the systems that is involved in an ecological system like more passionately, because their life is so like bound to the nature and land and everything. So, you know, like I focused on how traditional knowledge was important. And there was a case in Finland in which ecological restoration was done with the help of scientific knowledge as well as traditional knowledge. And it is one of the good examples how like good climate governance can also bring out like good results and effectively help in ecological restoration. So, you know, that's how I am not using any conceptual framework to tackle the challenges, but, you know, I'm trying to talk about how combining both knowledge systems can help us getting results, which are important right now. So I think that's my answer.
Thanks very much, Poonam, and you're well within time, so thank you for that. Orla, would you like to go next, please?
Sure, yeah. So I hope I kind of noted down all the questions, okay, and if I've forgotten anything, please feel free to follow up. But in terms of my sort of methodology and case choice, so yeah, I focus on Ireland and the Netherlands, and I try to use different sort of, through different papers, so different conceptual frameworks for sort of understanding how these two cases that have kind of made it all the way to the relevant Supreme Courts, using kind of similar law, like both using, for example, ECHR law and human rights law, how they could kind of be quite different. So this particular paper, I find that like climate justice lens a really interesting way of sort of comparing them and how different they can be. So I suppose it's, yeah, combining this sort of conceptual framework with a sort of a comparative approach to really, you know, understand how they can be so different. So there's a kind of an element of comparative constitutionalism in there. In terms of the social movement question, I really find that one fascinating too. It's I think even though, for example, so I suppose in the context of the Netherlands, after those judgments, you know, really put climate on the agenda in the Netherlands. You know, it's really hard, I think, and particularly for legal scholars maybe, to kind of map that sort of direct impact onto policy. But even within that time, you know, there was new climate targets being agreed, plans around, say, for example, closing down fossil fuel infrastructure, and within the Irish context, like even it, you know, and we'll never really know, was it because of, or just was it in parallel or something, but you know, between after the National Mitigation Plan, we had this Climate Action Plan, which probably didn't fully align with kind of 1.5 degrees or 2 degrees target, but still was a step in the right direction. So I think, you know, there's definitely wider kind of social impacts of these cases, even if they're not necessarily successful in first instance. So yeah, I think that covers a lot of it. Oh, I suppose, yeah, I mean, a really big thing, and I totally agree, and I kind of struggle to reconcile this myself, you know, how do we fully incorporate the just transition piece into all of this? And I don't really tackle it kind of head on in my own PhD research, but I do kind of write about it kind of alongside a little bit. I think there's a really big space for that. Like, for example, in Ireland at the minute, we are revising our climate act. So the act that was actually in question in the climate case, that's being revised. So there's an opportunity there, I would think, or I'd hope for that to be properly incorporated into the act. And, you know, not just in this sort of watery like mention, but actually in a meaningful way. And I think, yeah, there's lessons to be learned from other countries, for example, Scotland and how they've done it. So not exactly kind of what I've been focusing on fully on my PhD, but definitely very relevant in terms of how we're actually going to, yeah, kind of achieve decarbonisation in a climate just way, I suppose. So, yeah, I hope that kind of touched on the questions properly.
No, absolutely, Orla. And if I may, Anurag, quick question. Really interesting, Orla, and I'm wondering, like, have you paid attention to existing legislation in Ireland? For example, the Petroleum and Other Minerals Development Act, which really is about investing the state with ownership rights of hydrocarbons with a view to maximising production of those to generate revenue for the state, and the conflicts associated with that. Now, I'm not sure if you're following Breed Smith's Climate Emergency Measures Bill. So I was given evidence for Breed in 2018 when that was under consideration by the Oireachtas, but that brought together consideration of the Petroleum and Other Minerals Development Act in relation to the evolving climate legislation framework. So I'm just interested in those tensions, because implicit to the state and this act from 1960, there's a desire to continue to use fossil fuels for economic development activities within the state, and that's deeply embedded within how the state functions as a neoliberal capitalist state. The privatisation and drive to maximise extraction, and the conflicts then that is manifest when you have a piece of legislation which doesn't, implicitly is about using resources for extraction and sale, how that then aligns with climate legislation. Yeah. I know that's under development, so it's probably a bit abstract to ask.
No, absolutely, because I suppose all these things are kind of proceeding in parallel, and none of them are, you know, kind of occurring in a vacuum. I actually think one really interesting thing about the Irish climate case, which I've written a small bit about, is so even though the Supreme Court didn't actually fully rule on the constitutional and human rights points, it did sort of leave a few doors open in terms of what it might entertain in the future. So it said, okay, this is an NGO, they're not entitled to litigate these personal rights. But it did sort of say, well, in the future, we're not ruling out constitutional environmental litigation. We might be, or if the court might, for example, entertain cases relating to, one of the things they referred to was Article 10 of the Irish Constitution, which refers to the natural resources being within the ownership of the state. So even though in that context, the Irish Supreme Court said we're not recognising a right to a healthy environment, they at least left this sort of opportunity there, if you like. So I think yeah, the kind of ability for maybe that kind of environmental constitutionalism to interact in a way with these kind of legislative developments is very interesting. But yeah, so I suppose it's a very much a live area, and hopefully within the new climate bill, some of these things might even, you know, be addressed. We can keep our fingers crossed.
Thanks very much, Orla and Amanda. Thank you, Lee. Thank you, Poonam, for both your incredibly interesting presentations, but also talking about your actual research and talking about your methodologies. I mean, my sort of PhD is in law, and working with Amanda in SECA, I have a great interest in climate law, and so I found these discussions particularly interesting, looking at your kind of insights into the Urgenda case, into the Friends of the Irish Environment case, into petitions at the Inter-American Court of Human Rights, and the ways in which the voices of Indigenous peoples can actually be heard in sort of juridical forums. So I was fascinated, and I am very hopeful that we can continue to have these conversations in the future. While I was also hopeful that we might have some time for questions. Unfortunately, with the time, I mean, we have a minute. If anybody wants to ask a super fast question that has a super fast answer, we have a minute left. But otherwise, I don't see. Yeah, okay, great comment from John Taggart there. But otherwise, if there are no questions, thank you again to Lee, Poonam, and Orla, our great presenters this afternoon. And thank you very much to Amanda Slevin, who beautifully drew all of the papers together and gave us some incredibly insightful matters to talk about. Hopefully in the immediate future, but also hopefully we can continue talking about these issues in the long-term future, because of course, as we all know, climate change is not about to stop happening tomorrow. So thank you very much for participating in this. We are going to be taking a